Hi all, and welcome to an awesome webinar that we have planned for you today. We're talking life, death and money, what you need to know and do to best organise your finances for retirement and beyond. Now, it isn't a subject that many of us are comfortable with, but death is inevitable. But today isn't all about preparing for the grave. It is about planning for a happy and financially secure retirement where you can live your golden years free of financial worries. To ensure your many years of hard work and paying taxes are maximised, careful planning is required. From preparing a will and accessing the pension to maximising your super, we will cover all of this today and more. And to help us, we are joined by your host, Patrick Dawson from Patrick Dawson Law and Zac Morden-Jones of AKW Financial Services. For those of you who don't know Patrick Dawson, he is the principal of Patrick Dawson Law in Narrandera, which started in 2019. With over 10 years of legal experience, Patrick is passionate about providing his clients with personalised guidance that delivers results. He is often commended by his colleagues for his collaborative approach in resolving disputes and achieving results for his clients. Stepping away from his traditional practice models, Patrick aims to drive his practice with a modern twist to provide a personalised, affordable and approachable service to his clients. Zac Morden-Jones, we're thrilled to have him joining us today. After completing university studies in Canberra in the ACT, Zac moved home to Wagga in 2015 to commence his career in the financial services industry. Zac has long held an interest in personal finance and believes financial education is vital for improving the quality of life for ourselves and our community. Outside of work, Zac has kept busy with his family, or is kept busy with his family of 3 young kids, and is active in the community as a member of South Wagga Apex. Thank you so much for joining us, gentlemen.
Thank you, Letitia.
That was a bit of a long introduction, but I felt like it was probably set today up because we are going to be covering a lot of really useful information. So really excited to jump right in. Patrick, I might actually start with you. I mean, you are the host of these webinars. We've done a couple of educational series now. Why have you chosen today's subject?
Well, Letitia, it's a very interesting topic, and I find myself I find a lot of clients are coming to me now with a lot of questions about estate planning, but more so tying that in with pensions, how to set themselves up to receive a pension, questions about superannuation. Now, whilst as a lawyer we can assist with the estate planning side of things, superannuation and pensions are financial services, which is why I've sort of included Zac today to share some of his knowledge and expertise about this topic.
And similar with you, Zac, what sort of interested you about participating in this webinar?
Well, like Pat pointed out, these are common questions that I also come across. And look, while the information is out there and is accessible, as we're aware, we're in the age of information, and we're not struggling from a lack of information. It's often quite the opposite, an overload of information. So getting to the bottom of the questions can be quite difficult for clients acting on their own accord. So if we're able to break down some of those common questions that we come across and provide some useful information to the listeners, then I think it's worthwhile.
Absolutely. And as I said in the lead-in, not many people like talking about death. And I know you and I, Patrick, have spoken offline about this before, how it's sort of it sends you a little bit crazy, the amount of people who don't have wills. Let's start there. What is a will and why do we need one?
No, that's incredibly true, Letitia. It is disappointing sometimes to hear when people don't have a will. And especially at all ages, a lot of 18-year-olds or even early 20s come to me and say, well, I don't have any assets, so why do I need a will? Well, firstly, in answer to your question, a will is a document that sets out a person's wishes for when they pass away. So there's a few key components. The first one is your executor, so the appointment of an executor, and that's it. That role is basically a person who organises the funeral, pays out all the creditors, and then distributes funds to beneficiaries. Then you might have an appointment for the guardian of minor children in there as well. You might want to set up provision for people outside of your immediate family, people outside, set up provision for charities. And if you don't have these wishes recorded within a will, it may not necessarily, your estate may not necessarily vest in the manner or way that you choose or wanted.
I think one of the common things I hear is, well, it'll all just go to my kids or my spouse anyway. Is that technically correct? If you do die and you don't have a will it just automatically go to those people?
So to an extent, so what happens when a person passes away without a will, it's what we call an intestacy. So we have legislation that sets out what happens on intestacy. So by default, it would go to the usual course of action. It goes to a spouse, then it goes to a child, then grandchild, and so on and so forth. But where it can get really messy and tricky is one example is a separation. So, if parties had separated and one of them hasn't updated their will, they haven't gone through their property settlement, they haven't finalised their divorce, by default, their ex-partner could end up with their estate.
Yeah, but I know most people wouldn't want that. So you mentioned earlier power of attorney. What is a power of attorney and enduring guardianship in particular?
Yeah, sure. So power of attorney is a document that is used to appoint another person to manage financial affairs. The most common example would be individuals appointing someone in case they lose mental capacity. Now, as a power of attorney, they can basically do anything that you can, like buy and sell property. They can pay your bills, all those sorts of things. And but it doesn't strictly have to be that on loss of capacity. You can set it up to be effective from, for example, when the attorney accepts their position, and there's reasons why you may or may not do that. So a common example would be someone who may have mental capacity but is not necessarily physically mobile. So you would set it up that way so that they had someone to attend to all those financial affairs. With the enduring guardian, it's a similar document, but that's to do with health and lifestyle. So that's decisions about where a person lives, what personal services they receive, what healthcare they receive, and to consent to medical or dental treatment on that person's behalf. Another aspect to the enduring guardian document is that you can put in there a direction to basically flick the switch. So if there's no prospects of the individual's survival, then the enduring guardian, on a doctor's advice, can make that decision not to receive palliative care, be kept comfortable, and be allowed to die.
And if you've got your wishes laid out in the will, then that enduring guardian has to obviously work to your wishes that you've outlined in the will, I'm guessing?
So the will sort of exists. So the enduring guardian and power of attorney are only in effect whilst the person is alive. And then when the person passes away, that's when the will takes effect. But it is, especially with the enduring guardian and with that direction I was referring to, it's my opinion that it's more so to protect the guardian than the individual. And I'll give you an example. So say if a child had to make that decision about their parents, but their siblings are not necessarily agreeing, by having it clearly set out, the child that has to make the decision their position can be supported by a document signed by their parents.
Okay, so it's saving potentially a little bit of heartache and argument, although arguments can still take place with people contesting. So I'm sure it's not.
Yeah, absolutely.
Avoiding any form of conflict there. So what happens if you don't have those living documents, such as the power of attorney and enduring guardian, apart from potential arguments with siblings?
Yeah, well, there is another process. So you can, in New South Wales, we have the New South Wales Civil and Administrative Tribunal, or NCAT, and a member of the family can apply to the tribunal to be appointed as a guardian and a financial manager. it is a bit more of a process. It's not as straightforward as having the documents drawn up by a solicitor. And in terms of if you are acting as a financial manager, every year you have to provide accounts to the New South Wales Public Trustee, so they basically audit the process to ensure that you're acting appropriately. But if you have a power of attorney in place, there isn't that stringent process involved.
Zac, is there anything you'd like to add while we're talking about wills? I know that's not strictly financial advisor land, but in your experience talking with clients, is there anything you'd like to add?
I think what I notice is a lot of clients don't realise the importance of having the power of attorney and the enduring power of guardianship in place, and quite often they don't actually understand the difference between, say, a general power of attorney and an enduring power of attorney. It's not too common, but I have come across several cases where there might be a general power of attorney in place, and the clients, Patrick, this is your area of expertise, but the clients aren't aware that if they did lose mental capacity, that wouldn't actually play a role. So what's your sort of steered approach there, Patrick? Is it common practice for yourself to usually opt for the enduring power of attorney, or does the general power of attorney still play a role in there?
Yeah, good question, Zac. So with the in 99% of the cases, it will be an enduring power of attorney. And what makes it enduring is that obviously it continues to be effective once the person loses mental capacity. A general power of attorney, well, from my practice, would only really be used for a specific purpose. So say, for example, Zac, you're working with AKW, your supervisor or your supervising partner might be overseas and needing a signatory within the office. So they may provide a general power of attorney for you to do that whilst they're overseas for that specific purpose.
Yeah, excellent. That's quite useful, I think. Useful information for everyone to understand, because at some point it will likely impact us.
Yeah, absolutely. And to follow on from that too, Zac, a lot of people think, oh, this is something that I don't have to worry about. I don't have to worry about till I'm older. But it doesn't hurt to have these documents in place, even from a young age, because anything can happen. Hit by the bus theory tomorrow, you might be lose capacity then. And at least if it's in place, then there's no issues for the family down the track. And I myself have got those documents in place and have had them probably since I was about 21, only because I work in the industry, and I am aware of what happens when they're not in place.
So
yeah, you're exactly right. Sorry, Letitia. I'm constantly telling my clients that if they don't have the documents in place, to go speak to someone, because by the time they need them, it's too late. So
yeah, that's true.
Yeah, you've got to do.
Just on that, we're talking about personal situations a lot, but what happens if, for example, Patrick and myself, we run our own businesses? How does it also play into business owner lives? I'm assuming that that's something that most business owners potentially haven't thought of. What happens to my business if something happens to me?
Yeah, that's a good question as well, Letitia. So basically, your attorney can step into that role. So let's assume that you operate through a company and you're a director of that company, then your appointed attorney can step into that role as director and carry out the duties that you need to carry out for your business, which is, I guess, even more so a reason to have it in place, because you may not necessarily want someone within your family taking on that role. You might want a colleague, or you might have another partner in the business to fill that role.
And what about these will kits that people can just pick up for free? What's the difference between doing it yourself through a will kit like that I believe you can still get it from post office and places like that, versus paying a specialised attorney?
Yeah, sure. So the will kit executed properly, like I'll be perfectly honest, is a perfectly valid will. However, where the traps and things lie is not understanding what happens with the will and what happens with certain property. So a common example is property that might be owned by a trust or like a family trust, property that might be owned by a self-managed super fund. If you're not factoring in that ownership, people will try and gift those assets under their will, but in effect they will fail because they're not the individual's assets to give. And if you've got 3 children and one child's getting the family trust, one child's getting the contents of the self-managed super fund, and the other child might be getting the personal contents of the family unit, well, the only one that's going to potentially benefit is the one that's receiving the personal assets.
So it sounds like the more complex your personal and financial and business situation is, the more you definitely need to seek out not only legal advice, but financial advice, which does bring me to a disclaimer that I should have probably said at the beginning. It should be noted that this recording is for information purposes only, and you should obtain independent legal and financial advice for any of the things that we're talking about today. If we move on to, death aside, we live so much longer now, and people generally aim to retire by 60 or 70. And for those years, most of us have worked really, really hard, with most of us starting around 14, 15 years of age. Zac, I'll ask these questions about the pension to you. What is the aged care pension? Because I think the news sort of makes most of us think that we shouldn't be relying on it to retire on.
Yeah, you're certainly right there, Letitia. So firstly, the age pension, it forms one part, but I would say a predominant part of Australia's social security system. And it's an ongoing pension, fortnightly pension that eligible recipients receive, along with some other benefits such as reduced utility bills, reduced car operating costs, and pharmaceutical benefits and things like that. But the main benefit of the age pension is that fortnightly pension payment that assists retirees throughout their retirement. Now, you raised a very good point there. The age pension, it's not an enormous amount, so it can be quite difficult to solely rely on that pension payment for your retirement. And then we would certainly encourage people who have the capacity to do so to set themselves up to a certain extent financially so that they're not solely reliant on that age pension.
So
give a bit of an idea. Oh, yep, you go.
If I have it correct, you've got the full government pension you've got 3 areas of reliance. You've got being completely reliant on the government pension, being partly self-funded and still receiving a reduced government pension, or you've got full self-funded. Is that correct? Have I got the correct synopsis?
Yes, yep, absolutely. So the way it works is, if you are eligible for the age pension, you're either eligible for what's known as the full benefit or a part benefit. And your eligibility can change over the years. So it's important to understand that even though you may be ineligible for any age pension currently, if your circumstances change in 2 years' time, you may certainly become eligible. So it is assessed, or you can be assessed on an ongoing basis. But yes, exactly right. As you pointed out, you're either considered a full retiree, meaning a fully funded retiree, meaning you're not eligible for any part age pension. You may be eligible for a portion of the regular age pension, depending on your financial position, or potentially the full age pension.
And if people want to, people like me, I can't see myself retiring completely because I think it would bore me. I might be wrong when I get to that age, but have you got the option of still being able to work even just a few hours without it affecting your pension?
Definitely. So the government does encourage age pension recipients, or those who have reached age pension age, to continue working. Now, firstly, I should point out that the way the age pension assessment works is two financial means tests that apply. So there's an asset test and an income test. Now, the income test is where, let's just say, you continue to work, even if it's on a part-time basis throughout your retirement. The income that you earn from that employment or that self-employment would factor into that income test of the age pension. Now, the government does allow what's called a work bonus. So for those receiving income from employment or active self-employment, they will exclude or disregard the first $300 of fortnightly earnings from that income test. And then the income test alone, it also allows for income to be earned before any reduction to the age pension. So yes, you certainly can continue working, and that can be a great way to supplement that age pension, providing a bit of a better lifestyle throughout retirement.
Patrick, for you, what are some of the most common questions people are asking you around their pension and retirement?
Yeah, sure. So one of the most common question I do get asked is, if I transfer my principal place of residence or my investment property to my kids, does that mean I'll receive a pension? So I might throw that one over to Zac to answer and discuss what the parameters are around that and gifting.
So, great question. I come across this a lot also, Patrick, and the answer is potentially. So, firstly, as I mentioned, your eligibility will be assessed based on your overall financial position, being your asset position and also the income that you're earning or the income that you're deemed to have earned in Centrelink size. Now, where the gifting of assets factors in is to the asset test. Okay, so let's just say you're ineligible for any age pension because your assets are above the upper threshold. If you gift away assets of a significant value, Centrelink will continue to assume or continue to assess those assets as being held in your name for 5 years after the gift. Okay, so after that 5-year period has ceased, then yes, they will reduce your assets by the value of the gifted assets, so hence potentially, but during those 5 years, it still will be assessed under your name. Now, I should also point out on a much smaller scale, Centrelink will allow you to gift and subsequently reduce your assessable assets by $10,000 per year, up to a maximum of $30,000 over 5 years.
So just on that, when we're talking about assets, what are considered assets in the eyes of the government assessing our pension, I guess?
Eligibility. So most of our assets. Most notably though, the family home or the principal residence is excluded from that assessment. So that has the largest impact, but they will assess almost all other assets, and that includes your home contents, cars, caravans, any other lifestyle assets we may have, in addition to our financial assets, so money in the bank, term deposits, shares, superannuation, and so on. Now, there are some assets that Centrelink allows us to exclude from that assessment, but beyond the family home, it is quite limited. Things like prepaid funeral expenses and some investment bonds and things like that are assessed differently. But for the sake of simplicity today, essentially it will generally be all your assets excluding the family home.
A lot of people think that a family trust or setting things up in companies are a great way to, I guess, dodge the system and come up with back-end loopholes. Is that necessarily true? And this is sort of a question directed at both of you when we're talking about the pension, but also estate planning. I'll start with you, Zac.
Yeah, so from the pension assessment point of view, age pension assessment point of view, Centrelink will look at your overall financial circumstances, and they will factor in assets that you are either the beneficial owner from or have control over. So it's very, very difficult for those types of strategies to provide a benefit from the age pension perspective.
And for you, Patrick, what are some of the misconceptions that you see most when people are planning their retirement and estate planning?
In terms of using family trusts and other sorts of business models. From an estate planning perspective, it's more so being aware about how that trust operates, who is the beneficial owner, and as Zac mentioned before, who's in the controlling position. Because essentially, using the family trust model as an example, the person in the controlling position is the one that is responsible for or can control the distribution of income. On that side of things, it's more so being aware and carefully drafting it into the will itself.
Because I'm guessing, and this is probably more of a question for you, Zac, or actually no, you, Patrick, I might be wrong. Transferring properties comes with risk, like the beneficiary and ownership of properties, because stamp duty should be considered, I'm guessing, when you're transferring ownership.
So from an estate perspective, gifting or transferring properties can be, in New South Wales, and I will clarify that this is a New South Wales concept, can potentially pose risks later on down the track. So, for example, it can often be the case where a child wants to receive the family home, goes down to the solicitor's office, arranges for the parent to transfer the home to the child at no value. So basically gifting the house to the child. If for whatever reason something happened to the parent within 3 years from the date of the transfer, that transaction can potentially be undone should someone claim against the estate. So when doing these types of transfers, and even if it was for the purposes of receiving a pension or something like that, whatever the reason is, that 3-year rule or notional estate is a very real consideration. So and it can be a costly exercise should a claim be made against the estate.
Did not know that. That's scary.
I would also just add to your point that question there, Letitia, that yes, the stamp duty, but also potential capital gains tax implications of transferring assets needs to be considered before that decision is made. Yeah,
absolutely. I'm often privy to people having conversations around how they're going to, transfer their properties into their children's names, or into a trust or a company, and make their children the beneficiary. And I think there's a huge misunderstanding around what the implications are, as we've just talked about, from a tax perspective, stamp duty, and potential, recourse with that 3-year time limit. So that's super interesting, just for people to be aware that things aren't always as cut and dry as you may think them to be. And I think there's a lot of wives' tales and people who have advice that may not be actually professionally trained to give that advice. Friends and family, I'm thinking mainly. So let's talk about superannuation, because over the past 2 years, the government has made it a lot easier for people to access lump sums of their superannuation during COVID. What are the benefits of, that's sort of people pre-retirement, but if we talk about preparing for retirement, is it better to actually draw out people's super as a lump sum, or take it as an allowance when they're going into retirement?
So generally speaking, it would usually be better for someone to take their superannuation benefits as an ongoing income stream throughout retirement. Now, I should point out that obviously it does, this decision is impacted by personal circumstances and your broader financial position. But the reason I say that is because superannuation is a favourably taxed environment, and once you reach retirement, it's often the case that your super benefits are held in a completely tax-free environment. So it makes a lot of sense to retain those benefits and keep them invested in potentially a tax-free environment and draw an ongoing income from those investments, rather than taking it out as a lump sum and then deciding what's going to happen or how you're going to invest those proceeds in what is potentially a taxed environment.
Can you just explain a little bit more about what you mean there around the more favourably, I can't remember your specific wording, but
the tax characteristics of super? Yeah, definitely. A good area to touch on as well, because I do get a lot of questions in this regard. So superannuation, there's two sides to superannuation, one being the accumulation side and one the pension side. So for retirees, or I should say, once we've satisfied a condition of release and have access to our super benefits, then we're generally able to transfer the majority, if not all, of our super benefits to the pension side of super, which is a tax-free environment. So the idea is throughout retirement, we benefit from having our capital and future earnings tax-free in that environment, and then we can draw tax-free income from that side of super. Now, the accumulation side is what we hold when we're working and growing our super and contributing to super. And that also is, I should say, favourably taxed compared to many other entities, including our personal names from a tax perspective. So the accumulation side of super is taxed up to a cap of 15%. So it still is quite a low tax rate.
Patrick, is there anything you'd like to add there with some of the main questions that you get asked?
With superannuation, I mean, with estate planning, one of the things I do like to cover off with clients is the treatment of superannuation. Generally speaking, superannuation will fall outside of the estate unless you direct it there. So it's always recommended that individuals complete what's called a binding nomination, and that's to nominate a beneficiary for your super. So you can either nominate an individual or individuals in whatever shares you stipulate, and you can also nominate your personal legal representative, which sends it to the estate. So there's various reasons why you would do both for taxation purposes, and normally that's where we are guided by accountants and financial planners like Zac as to what is best for our client when directing their super. And I'm sure Zac probably goes through completes a number of binding nominations at work. So yeah, that's the estate planning side of it.
Zac, I touched a little bit earlier about people taking out $10,000, $20,000 out of their super because the government allowed them to during COVID. Is that a bit of a dangerous pattern to get into? I mean, I'm not saying that the government will or won't allow that kind of access again in the future, but at the time there were many people on both sides of the camp saying, yes, it's a great idea, and others saying, no, this is going to cost these people long term a lot more than what they think about. I think because, we don't see that money. If we're wage earners, we don't see that money going from our hands to the bank account. I think there's this notion in people's mind that it's easy money, and they don't have that same relationship with it. Is that a dangerous sort of notion to have?
Yes, it is. I completely agree, Letitia, and you're right. A lot of people do have that mindset. I'm always encouraging people, particularly younger people, to view superannuation and their employer super contributions as part of their income, because essentially that's what it is. It's part of their remuneration package. And if superannuation didn't exist, then it's highly likely they would be receiving that directly. So superannuation is a great system. It provides some level of forced saving for our future benefit in retirement. which many of us often need. And yes, the risk being that if we're not mindful of the impacts that those early withdrawals can have, it's going to leave us short in retirement and potentially reliant more on Australia's social security system, such as the age pension. So we've just got to be mindful and really, make some sensible decisions. I think it's great the government allowed access to super during what was a very tough period for some people, and if you certainly needed financial assistance during that period, then by all means, that's one consideration that needs to be made, and it was great they had the option to consider that. But we also saw a lot of withdrawals from super that may not have been completely required. So it's just a matter of really thinking, okay, what impact is this going to have on me? It's $10,000 now, but that could potentially mean $50,000 less that I have in retirement, which is quite substantial.
So we were talking about, when you move over to that retirement phase, you're not taxed on that superannuation when you're drawing down on that. But what if you're drawing down before retirement? What's the tax repercussions there?
That is a very complex area. So it depends. There's certain factors that come into that decision making. It depends on your age and your income level as to how much tax there would be, and it also is impacted by the type of components that you hold within your super account. I would strongly encourage anyone who's accessing their super early to get individual advice to consider the tax impacts prior to doing that, because it will vary case by case depending on their individual super benefits as well as their personal income circumstance. But the way super is designed, it is designed to benefit us later in life. So I think it's important to point out to anyone listening that, generally speaking, once you reach age 60, you will usually be able to withdraw your super benefits tax-free. Now, that is not always the case. So once again, it's important to consider relative to your individual circumstance, but generally speaking, that's the case.
Did you have anything that you wanted to add there, Patrick?
No, I think that's more Zac's area of expertise. Yeah.
Yeah, no, that's fine. And in terms of when we talk about inheritance, I know we were talking about gifting properties and gifting money and all the rest of it, but what happens if we get a lump sum of inheritance or win the lottery? How can that affect, I guess, the whole situation approaching retirement? What should we be doing there? Would it be best to pump it into super? Is it better to, consider the effects that might have on being able to access this pension, if it does at all? I mean, does winning the lottery affect your pension?
So yes, it certainly does. As we've sort of explained throughout this chat, your age pension eligibility is based on your overall financial position. So from an asset test perspective, there are various categories, but just to give a general idea, for a couple who have met their age pension age and then apply for the age pension, they can have assets of up to around $900,000 before they become ineligible for the age pension, and that is assessable assets. So that's excluding their principal residence or the family home. So where an inheritance or a windfall would factor in is it would increase their assessable assets. Now, it's important to understand that if we're ineligible for the age pension, that means we're in a good financial position, and we're better off than if, financially speaking, than if we were eligible for the age pension. Okay, and as I also mentioned, as our circumstances change over time, whether we enjoy ourselves a great deal and spend a whole heap of money, we can certainly become eligible at future stages. So what should you do with the money if you do receive a windfall? Well, once again, it does depend on what you're trying to achieve, but that's the first step, is really sit down and understand the purpose or what you would like to achieve from this money. And that's such an important step, but it's often an overlooked step, because that will determine not only the suitable structure for that money, superannuation being only one option, but also the ideal investment type for that money. Now, secondly, I would say only invest in something that you understand. And thirdly, once you've got those two steps really understood and defined, then take action. Time and time again, I see people sort of worrying themselves into inaction. And I think they could be worried about the economy, worried about financial markets, worried about the timing of their investment. And too often I do see that lack of action is one of the main factors for people not achieving their goals, which is really unfortunate. But just going back to that first point, understanding what you're trying to achieve. Yes, superannuation is a great structure. There's a lot of benefits involved, but there are also disadvantages, most notably the access requirements. So it's important to consider what we're trying to achieve and considering all options available, which might involve investing through other structures that have been mentioned on this chat, individually, family trusts, company structures, and so on. Superannuation just forms one part of a much broader range of options available.
Yeah, absolutely. And people are, they've got can have such a diverse range of investments. We're seeing a lot of people investing in cryptocurrencies and blockchain and things like that. So I think there's a layer of complexity even around that, because it is such a new world. Are there any considerations people need to make around, pouring money into crypto if they are approaching that pension age, apart from the fact that it will be considered an asset?
Definitely. So that was point 2 that I just made before: invest in what you understand. And I think if you asked a lot of people that were considering investing in cryptocurrency, do you understand it? On the top level, yes, they may to a certain extent, but I really don't think they would fully understand the implications and how that fits into their investment strategy. So every investment strategy has to be based on your purpose and what you're trying to achieve. And generally speaking, for people shifting into retirement, it's very income focused. Okay, we need income in retirement to support our lifestyle. So investment into assets that provide no income at all has to be questioned, and we really have to thoroughly think about that before jumping into anything like that.
Yeah, absolutely. Patrick, anything on that front with, perhaps some misunderstandings people have around cryptocurrencies and how that not only plays out in wills and estate planning, but potentially even family law?
Not so much about the cryptocurrency, but I do have another question for Zac. And I think just it just seems to be this common theme, along with a lot of my clients with coming in for estate planning purposes and things like that, is to just, I think we've touched on this throughout the course of this webinar, is to just offload assets and get rid of the assets so they can get the pension. But I guess, and I know this is probably relevant to the individual, but sometimes I almost wish to say to them, like, is it really worth it? Like, is it really worth offloading $1 million worth of assets to collect your pension? Like, you've worked hard, you've accumulated your wealth. Like, what are your thoughts on that, Zac?
Can we just actually set that up? I mean, what is at present, what is the maximum amount of pension a person can receive, whether they're a single or a couple? Because, fair point, Patrick, like, is it actually worth, I think people have this idea that, well, it's free money, but how much is it really?
Great points. So firstly, what is the maximum age pension you can receive? Well, for a single person, it's just under $1,000 per fortnight. And for a couple, it's just under, currently, $1,500 per fortnight. Okay, so for a couple in retirement, $1,500 per fortnight, is that worth giving away $1 million worth of income producing assets? From a financial perspective, probably not. Now, where it can tie in and actually create a benefit is where there's, say, for example, family businesses involved, if it's a family farm or something like that, and the intention is for those assets to go through to future beneficial or future generations at some point. And particularly with agricultural land at the moment, very high asset values, and if the client in question is not receiving very much income from that asset, or expects to not be receiving much income from that asset in the future, then it could well be a great option. But for someone, on the other hand, with $1 million in property or shares, it's providing quite a good return over time. Transferring that for potentially $1,000 or $1,500 per fortnight from the age pension doesn't make much financial sense.
Yeah, absolutely. And just in terms of how people should approach this, so if they're in the situation where, they might have a few assets and they're wanting to plan their will, look at all those other living documents, Patrick, is it best that they talk to a financial advisor first so they can direct you exactly what they need? Or is it like a side-by-side, let's work through this as two professionals with the client at the same time? How does it work? Is it a cart before the horse or the chicken egg, or like what should a person do? What are the actual steps?
I think the collaborative approach is best. Working with the financial planner, working with the accountant, and drafting the documents almost together, because we're talking about pensions and gifts and things like that, but there's also the taxation considerations as well. If properties are sold, I think Zac touched on this before, like capital gains tax and everything else like that. But I think that collaborative approach would definitely be beneficial for a client.
Exactly. Yeah, that's definitely my preference as well.
Yeah, awesome. Is there anything else that either of you would like to add that we haven't potentially covered already?
I would just point out, because we've been discussing on the age pension side of things, if there are any listeners that say are receiving a part age pension and are not entirely sure whether they're receiving what they're entitled to, it's always worth reviewing. So if you're quite diligent in that area and you do regularly update all your details with Centrelink, then chances are you are receiving what you're entitled to. But quite often it's the case that doesn't take place. And if that hasn't been updated for some time, then you may be eligible for a higher payment than you are receiving, particularly if your assets have gradually declined over the years. So it's just worth keeping that in mind.
Yeah, awesome. Anything from your end, Patrick?
I think just on the estate planning side, reviewing your documents regularly is a good idea, especially if assets are being moved around and things like that, because it could be detrimental on the other end.
Here's a question. When you say review it regularly, what are some of the, changes that could, in a person's life, that could affect when they need to update? I mean, the obvious one is a divorce or separation. That affects your estate. But what about anything else? Legally changing your name or doing all of those sorts of things? Yeah,
so legally changing your name, a marriage, children, if there's additional children.
Purchasing property, I'm guessing.
Yeah, if you've bought and sold property, if you've given specific gifts under your will, where they're up to, all sorts of things. Changes in your family dynamics, like whether or not, and it's a fact really, disputes happen, families can fall apart. So all these types of events, it's really important to review it.
And look, that is, we won't go into it much today, obviously, but contesting wills is a thing. And I know that you and I have talked about that as a service that you offer. What are the key points people need to consider when they're thinking about contesting a will?
So it's not as contesting a will is not as straightforward as what people generally think, or what I should say is what the media portrays, or what you see in sort of your movies and everything else like that. So to give you a brief overview, in New South Wales, there's two criteria. There's firstly eligibility. So there's a strict class of people who are eligible to claim on the estate or contest a will. So that's a spouse, a child of the deceased, a grandchild who lived with the deceased, and any person living in a close personal relationship with the deceased. So they can bring a claim on the estate. Then they have to establish that they haven't been adequately and properly provided for under the will. And then they also have to demonstrate a financial need. So, if one of the children is a multi-millionaire, then they can't just claim on principle. Like, they have to prove a financial need.
Yeah, it all sounds like there's so many complexities with everything that we've spoken today about. It's not just a hard and fast rule specifically. It all sounds very much dependent on what your personal situation is and what you're wanting from for your future and after your death. So thank you so much for both of you giving up your time today and providing a little bit more insight around this. Zac, any final last words that you'd like to add?
No, I think we've covered off on pretty much everything. So thank you, Letitia, and thank you, Patrick. Pleasure to be on the call, and thanks for the invitation.
And if people are wanting a little bit of financial advice, how do they get in contact with you?
So you can search us. We are on the major social media platforms, or just a Google search. That's AKW Financial Services.
Excellent. Patrick, any final words?
I'd just like to thank you both as well for participating in today and touching on these very interesting and important topics. Letitia, as always, thank you very much for your hosting and asking all the questions. And Zac, thank you for all your insightful information. It's certainly going to make my job easier moving forward, and being able to refer clients on to someone who can give them that financial advice.
You're very welcome.
Thank you, and vice versa.
Yeah, absolutely. I was going to say the same thing. I find these sessions really informative, not only, being able to impart this education through these means to other people, but I learn a lot during this process as well. So thank you so much. And obviously, if anyone does need some legal assistance, either in the areas of family law, wills and estate planning, obviously we're talking today, or any other areas around commercial law, etc., please head to patrickdawsonlaw.com.au and reach out to his team and Patrick. So thank you so much for joining us, both of you.
Thank you.
Thanks again, Letitia.